Ever buy something big, like, say, a factory, and then later you hit a rough patch, things go south.
Yeah.
Makes you wonder, could that old deal come back to haunt you? Like, could it even land you in insolvency court?
You're hitting on a really interesting point there.
That's what we're diving deep into today. We're talking Indian corporate law, and specifically a case Sandeep Mittal versus MSAS Rec, India Ltd, and others.
Okay.
This NCLA ruling, and that's the National Company Law Appellate Tribunal,
Right.
has big implications for businesses, so buckle up, get ready to unpack it.
Absolutely. And this case, the details are so interesting.
Yeah.
It all starts with this company, MS Kanpati Pulp and Paper Limited, or GPPL.
Okay.
They were struggling, couldn't repay their loans to institutions, including the Gujarat State Financial Corporation, GSFC.
And I bet GSFC wasn't too thrilled about that. That's where things get juicy, right?
Yeah, GSFC ended up seizing GPPL's assets
All makes sense.
because of these unpaid loans. But then enter Shree Industries Limited, or SIL, and they see an opportunity. They buy those assets from GSFC.
Okay, so we've got our distressed company, we've got valuable assets, we've got a willing buyer. Where's the catch?
Well, the catch, like many things, is in the details. SIL agrees to pay a pretty hefty sum for these assets, Rs 3.88 crore.
Okay.
And here's the kicker. They actually made the initial payments towards this purchase. This wasn't just walking away from debt.
Hold on, so they're making payments, but somehow they still get slapped with an insolvency claim. This is where it gets a little wild.
Right. This is where our final player enters the scene. A creditor named AceRec India Limited. AceRec claims a massive debt from SIL. But the question is, did that initial sale agreement, did that actually qualify as financial debt under the Insolvency and Bankruptcy Code, the IBC? That is the million-dollar question that the NCLA had to figure out.
Okay, now we're getting to the heart of it. Financial debt sounds pretty straightforward.
You would think so, right?
But I have a sneaky suspicion that there's more to this term than meets the eye.
There's always a little more to it.
So we're left with this financial debt question. How the NCLA untangle it all?
Well, they had to really dig into, what does financial debt actually mean? Especially in the context of the IBC, right? Because normally we think about financial debt, it's like borrowing money. It's a loan. You're going to pay it back over time.
Right, like when you've got that mortgage, got to make those payments every month.
Exactly. But the NCLT, they zeroed in on this. The deal between SIL and GSFC, it wasn't set up as a loan.
Interesting.
It was a sale, an asset sale. So those payments that SIL was making, that was for the purchase price, not loan repayment.
Oh, okay. So even though there were payments happening, the whole agreement underneath it was different. Kind of like, I'm trying to think, like buying a car versus leasing one.
Perfect analogy.
You're paying either way, but it's a totally different deal at its core.
Exactly. You hit it right on the head. And there's another piece of this. Remember how SIL, they provided that deed of guarantee to GSFC?
Right. You mentioned that earlier.
Yeah.
Why is that important?
Well, the NCLA, too, looked at it as that deed, that was about making sure us SL held up their end of the purchase bargain. It wasn't evidence of a financial debt. Basically, they said that guarantee was there to ensure SL followed through on buying the stuff.
Wow, so it's a subtle difference, but it's huge EE in this case.
Huge difference.
So they're saying you can't just call any deal with, like, scheduled payments financial debt just because of that. It's got to be deeper, right? The heart of the agreement matters.
Absolutely. And that's why this ruling is a big deal. It brings some much needed clarity to this whole what is financial debt question, at least when it comes to the IBC.
Okay, so after all that legal back and forth, what was the final word? What did the NCLA decide?
They sided with SIL, said that sale agreement, not financial debt under the IBC.
So, win for SIL. But what's it mean for everyone else doing business? What are the big implications here?
Well, it sets a precedent, right?
Right.
It tells other businesses, hey, you can do asset sales without this fear of instantly triggering insolvency worries, even if you use payment installments.
It's got to be a load off for a lot of companies out there.
Oh, absolutely. But it does make you think. There's another question this whole thing brings up.
Which is COA. You were saying this ruling that kind of brings up another question, right?
Yeah, it makes you wonder, does this make it tougher for creditors to actually collect on legitimate debts?
That's a good point because, I mean, the IBC is there for a reason. It's supposed to be this whole system for handling insolvency fairly.
Exactly, and it highlights this constant tension. You're always balancing, right? Trying to protect creditors, but also make room for companies to restructure, Maybe even save some businesses and jobs in the process.
Right, so no easy answers, just a whole lot of gray area to navigate.
Absolutely, and that's what makes this ruling so fascinating. It forces you to think about those gray areas because what exactly is financial debt? It's not always clear cut, and how we decide to define it, that has some serious consequences.
It's like this one case just opened up a can of worms for the business world.
Totally, it really has. And if I can leave you with one last thought, it'd be this. How do you think this is going to affect how businesses make deals in the future? Like, are we going to see more companies structuring their agreements in very specific ways to avoid that financial debt label?
Now that is something to think about. This case might be closed, but it's definitely sparked a much bigger conversation about corporate law and what it means in the real world. Well, that about wraps up our deep dive into this fascinating case. We've gone through the ins and outs of sale agreements, untangled insolvency, and really dug into this whole idea of financial debt in the eyes of the law. Thanks for joining us on this journey. We hope you learned a thing or two along the way.